Hi, Alexandra Butyuk here, your GTA Realtor with Keller Williams Neighborhood, and
Oksana Mirotenko, your real estate lawyer.
We are talking today about pre-construction condos, specific topic of renting your unit while you are under occupancy. You have to review your paperwork properly, whether you can even advertise it. And it's not only talking about advertising on MLS, it can be in any social media. Can you give some samples?
Yeah, correct.
Examples?
Yeah, so basically when I review the agreement of purchase and sale, there is this always standard little clause saying that the purchaser can assign the unit, but there is a small wording saying, with the consent of builder, which consent can be arbitrarily withheld. What does it mean? It means that the builder can say yes, or they can say no, I don't agree to this. So I'm sorry, yes, you have this clause, but I don't agree. Let's say it's not selling well. We had cases once where the builder said that if 95% of the building will be sold, they will allow the assignment. And basically assignment means that somebody else will take over your contract. Let's say you purchased, and then you say, Oksana, I would like to assign it to you, meaning I have to pass the contract and everything to you, and now you will be the owner. So what happened in that case, the builder in the very end did not want to do an assignment, and what they did, they split the very last floor, which was a penthouse, into more units. So on paper, it was always less than 95% sold. So none of the people who purchased there, and many clients purchased there for investments, they could not assign. So that's one. Very important through your real estate agent, because we usually don't get involved because it's much longer process, because we have to contact the lawyer has to contact the builder, so it's a very long process. I would suggest through your real estate agent, you can prepare ahead of time the whole amendment. Amendment means change to the agreement of purchase and sale. Not your just standard clause that's always there, a little one, but the actual 2 pages where the builder says, yes, I will agree to an assignment. This will cost you, it's usually between $1,500 to $3,000 legal fees, which you will pay to my lawyer. And in this case, I will be able to sign, I'm signing this consent to assignment right now. So you know 100% that if you decide to assign, you have these 2 pages of paper signed by you and by the builder separately, in addition to your agreement, that gives you the right to assign.
So this is basically, we're talking about a sale of your property, but because you still don't own the property, you just own the paperwork, you sell the paperwork to another person.
Mm-hmm.
Then we have a real issue if the builder can allow you the assignment but would not allow you to advertise on MLS and any other sources. Right? So that's another clause that you can negotiate if you know going into the contract, if you have a realtor that can negotiate these things with you.
And, many people say, how would they know? Well, believe me, they do know. They check all the medias. I had a client who didn't tell me that she will be doing this assignment. She didn't say that she will be advertising. I told her, she signed all the documents that yes, she will not advertise, she will not sell. Next day, she put an advertisement on Kijiji, and guess what? 2 days later, the builder just sent us very, very nasty facts saying, it came to our attention that your client is actually advertising, so please, if she doesn't remove it, she will be in breach of contract. That means that she will lose all her deposits, the deal is off, and that's something that's very, very serious. The builder's lawyers have very strong litigation lawyers, so it's not a joke. It's a very, very serious matter, and they will go after you. So don't listen to your friends, to your family members who says, oh, I did it 10 years ago, was not an issue. Things really, really changed within the last year or 2. Many people are reviewed very seriously by Revenue Canada on a daily basis. Even if they did everything right, they come up for review every second day now. So just be cautious.
So that's one thing, and another thing, renting at the occupancy time. So what impact can that rent have on the owner?
So again, you have to have it in writing as a separate amendment to the agreement saying that the builder will allow you to rent your property. Now, remember, as we talked before, you are still not the owner. You are not on title of the property. You don't have your mortgage. Imagine you allowed people to go in, they sign a lease with you for 1 year, and then let's say in 6 months you have your final closing and you don't qualify for mortgage anymore because maybe you just lost your job. Maybe you went back to university and you didn't think that it will affect your mortgage now. So what happens now, technically, you cannot be the owner because you don't have a mortgage. So what happens to your tenants? They cannot live there because you're not the owner. So they have to vacate. So now you have not only a problem with the builder who will sue you because you don't have a mortgage and you will lose your deposit. That's the least that you will lose. If the property went down in value, the builder will also sue you for the difference. Let's say you bought for $500 and the property now is $400. They will sue you for $100,000 and they will win all the cases. It happened back in 2008 like that. So now going back to the tenants, you don't qualify for a mortgage, your tenant lives there, it's not his problem. Well, they cannot live there because you're not the owner anymore. So just be very, very cautious, because I would suggest maybe months to months tenancy, not 1 year lease, because you have no idea what will happen to you on final closing. If your situation changed, a lot of my clients buy, for example, for their children, they're hoping the children will live there, and then they move to Windsor or BC, and they don't purchase on closing with the son or daughter anymore. So they let the tenants in, everything is fine, it's already final closing coming up, and we advise the builder's lawyer that now, instead of the son being the purchaser, now the property will be rental. Okay, so the renters can go in, no problem, but big surprise, the person that's purchasing now will have to pay HST. And it's a huge amount. They will not get a rebate, which is maximum rebate is $24,000 if you purchase property over $500,000. And let's say you were hoping for this rebate and now you don't have it. So you have to personally pay the HST. If you have tenants which have lease with you for 1 year, if you are the registered owner for 1 year, you can apply to CRA for this rebate that I was just talking about. It will take a couple of weeks for them to get it back to you, but on final closing, you might be expected to pay extra $24,000, $25,000. Sometimes it's more because the rebate is $24,000, but I've seen as high as $37,000 that you didn't even think about on top of all the other extra costs. So just be very, very careful. When I meet with my clients for occupancy, I always ask them again, are you planning to leave there? Did something change there? Maybe your son is not going, so that they have that time, a couple of months to prepare financially, and they know going into the final closing that now they'll have to pay it, the HST.
Thank you so much.
Thank you. Good luck.
Thank you, Oksana.
And hope you talk to your professionals before you purchase.
Thank you. Thanks.